Assalamualaikum and a very good morning to our beloved lecturer Dr. Nur Aini Fatihah. Today, our group will present a poster regarding to a case study of Martin against UMI KELSOM. Our group consists of 4 people, which is Nur Izzati binti Sadeh, Nurul Aisyah binti Jamaluddin, Fateh Najwa binti Sulaiman, and Nurul Hidayu binti Muhammad Yani. So I want to place our first presenter, Fateh Najwa binti Sulaiman.
Okay, the first point is what action were taken in the case. First of all, in the case that an English court is confronted with a lawsuit that contains a foreign element, the private international law section of the English legal system kicks into gear. There is a wide range of family law in Malaysia, which has resulted in various interpersonal conflict amongst individuals. In addition, any person, with the exception of those who practice Islam, may have his or her marriage solemnized under the Civil Marriage Ordinance of 1952, which allow for civil monogamous marriage to be performed before register of marriage in Peninsular Malaysia. So the issue in Martin and Umi KELSOM was whether the marriage was void and unlawful on the ground that he was a Christian at the time of its solemnization and she was a Muslim, and consequently, by reason of her personal law, she was unable to intermarry with him. Yes, the petitioner requested that the marriage be ruled void ab initio, but the court determined the validity of the marriage according to the law of the husband domicile, which is in the case was English law, and having so determined that the marriage was valid. Despite widespread criticism, it is unclear that the decision would be followed today in the same way. It is possible to agree that the marriage was lawful under the law of the intended matrimonial domicile, which would be a valid defense. So moving on to the second point is where this action the most appropriate and why. So after the verdict in Martin and Umi KELSOM, the outcome is a bit baffling. This marriage between a Selangor lady and a Englishman was deemed legitimate in Selangor despite the woman's personal law prohibiting her from marry. So in this case, neither the petitioner nor the respondent contested the court jurisdiction because they were both resident when they are married. So the main concern was which law to obey. So Divorce Ordinance of 1952 state that the subject to the provision contained in the ordinance, the court shall act and give relief on principle which the court consider as nearly as possible to be conformable to the principle on which the High Court of Justice in England act and give relief in matrimonial proceeding. By referring to English law, the Chief Justice made it clear that English law encompasses the full corpus of English law, not only the principle of domestic English law. And according to his reasoning, the law of the site of celebration is the complete law of the location, and invalidity include inability. So in other words, the ruling introduced an English conflict of law basis whereby the English court may declare a marriage unlawful if one of the party cannot comply with the legislation on the location of celebration of the marriage. So in this case, it appears that applying English conflict of law standard to the circumstances is simple unless the party agree differently, whereas the question of the person's capacity to marry is decided by the law of the party intended abroad. So the marriage was pronounced null and void since the woman was just unable under both personal and domestic. Other cases that we can refer is Sotomayor and De Barros, where the judge concluded that a marriage was lawful since an exemption to a general norm existed. Next.
So next is, were there any consequences of the actions taken? So the conflict of law is the consequence in this case. So the alleged husband's personal law allowed him to marry the alleged wife, while the alleged wife's personal law prohibited her from marrying the alleged husband. So the basic point approved by the law is that a party's competence to contract a marriage is determined by his or her personal law at the time of the marriage contract, which is determined by residency. So these many legal systems that impact marriage vary in a variety of ways in response to a variety of issues. So they differ in terms of capacity. For example, in Section 10 of the Act, further specifies that no Muslim shall marry a non-Muslim. So in simple words, a Muslim woman is unable to marry a non-Muslim man, but a non-Muslim woman has no such restrictions. So next, yet there is a dispute here between the parties' personal law. So by his own law, the alleged husband was allowed to negotiate this marriage. So the alleged wife was unable to contract it due to her personal law. So it's useful to return to Section 3 of the Divorce Ordinance, which states that the court should act on the same principle as the English court in all procedures under it, which this proceeding is filed under. So an issue of conflict of law that occurs in respect to a subject over which the court has jurisdiction under the Divorce Ordinance is to be decided according to the same criteria as would be applied by the English courts. So the law that applies in England appears to be the same as it is in these circumstances, and there is no reason to believe that if it were applied to the hypothetical scenario of a marriage solemnized in London, the English courts would not maintain the legitimacy of that marriage. So in the situation of the alleged wife in this case, the answer is that her abode was in Malaya at the time of the marriage, and she belonged to a group of people who practice the Muslim religion and follow Islamic personal law. So the husband's residence was in England at the time of the marriage, and his personal law was English. So his personal law is not changed as a result of his change of residency to Malaya, because he now belongs to the group of people whose personal law is English law. So because this was the party's residence, they freely entered into a marriage contract and had it solemnized as per the legislation of the husband's residence. So as a result, the legitimacy of that marriage must be determined by this court under the statute, at least in the exercise of its power under the divorce ordinance. So they might have not passed a physical barrier, but they crossed a hypothetical line, which was a legal reality in the local context. So according to authorities cited, the marriage was therefore lawful. Next.
The next point was anything omitted or not considered? The circumstances in Martins against Umi Kalsum were that on February 25, 1950, the petitioner and respondent went through a form of wedding for Selangor in line with the term of the Christian marriage statute. At the time by the wedding, the petitioner was a Christian living in England and the respondent was a Muslim living in Selangor. The petitioner requested that the marriage be ruled void ab initio on the ground that he was a Christian at the time of its solemnization and the respondent was a Muslim, and therefore there was a bar from intermarrying with him under her personal law. Thompson CJ of the High Court held that in exercising its jurisdiction under the divorce ordinance, the court must determine the validity of the marriage according to the law of the husband domicile, which was English law, and that the marriage was thus determined to be valid. The decision was criticized and it dubious that it would be implemented today. It might be argued that the marriage was legitimate under the legislation of the intended marital domicile. Returning to the actual facts of the case that the marriage was solemnized in Kuala Lumpur, it is worth noting to limit the domicile of any person whose domicile the ordinary sense is in this country, at least in terms of personal law, does not depend on purely geographical and physical consideration, as it does in England, and of course in many other countries. It is not sufficient to inquire, is his home in Malaya? The issue then becomes, if his home is in Malaya, which of the group of people with diverse system of personal law does he belong to? In the situation of the putative wife in the current case, the answer is that at the time of the marriage, she was in Malaya. Among those who profess the Muslim religion and whose personal law is Islamic law, the husband abode was in England at the time of the marriage and his personal law was English law, and his personal law has not changed as a result of his change of domicile in Malaya, because his domicile now in Malaya among the group of people whose personal law is English law. Due to the parties' domicile, they willingly entered into a contract of marriage and had marriage solemnized in accordance with the legislation applicable to the husband domicile. As a result, the legitimacy of the marriage must be decided by this court, at least in the exercise of its power under the divorce ordinance. They may not have crossed a physical barrier, but they did cross a national line, which was also a legal reality in the local context. According to the agency side, the marriage was therefore legal. So I pass to the next presenter.
So the last point is where actions or procedures in line with existing codes of practice, policy or theories. The decision in this case, in my opinion, had an unusual outcome. A marriage performed in Selangor between a woman who is a Selangor resident at the time of the ceremony and a man who is a resident of England at the time is considered valid, even if the woman is unable to perform it under her personal law. The court's decision only confirmed their marital status under English law. They only married legally under the provisions of the Christian Marriage Enactment. In accordance with the Roman Catholic Christian marriage conditions, first, both men and women must have a will or desire to exist, which is consent. Second is no impediments such as those prescribed by canon law exist. Third, marriage ceremony Fourth, the wedding couple, which is male and female. Fifth, depending on the law, the groom must be 16 years old or older, and the bride must be 14 years old or older. Six, there are two witnesses, which is male and female. The witness cannot have a close relationship such as siblings and must be 21 years old or older. And the last one is the bride is the person who receives the marriage contract. According to Islamic law, the respondent lacked the capacity to marry the petitioner. The petitioner, on the other hand, as a domiciled Englishman, had no incapacity that prevented him from marrying the respondent, which both parties were full of age at the time of the marriage. Neither was married to anyone else, and they had no degree of affinity with each other. In terms of form, the marriage was solemnized in a form that was legally available to and binding on the petitioner, and in a form that was not done, as it now, because forbidden to a Muslim woman marrying a Christian. The fact that it was performed in accordance with the requirements of the Christian marriage enactment, however, did not make the marriage valid. Although the procedures is in line under English law, this marriage is illegal under Islamic law. So that's all from us. Thank you.